Before I start, I want to clarify, I have nothing to do with USDA. We don't work for USDA. We have nothing to do with writing or implementing these regulations or any laws. Instead, we are a nonpartisan and as unbiased as we can make it Center for Research and Education on the laws of the nation that relate to agriculture. We work on the state and federal level, but this presentation is going to be basically on the federal level. So I'm talking about confidentiality and liability under the NAIS system. When Dr. Clifford talked yesterday, he talked about 6 different concerns that were unilateral concerns throughout the listening sessions that they attended. And of those, 3 of them were legal concerns: confidentiality, liability, and if we have time, I'm going to talk a little bit about the religious freedom argument against NAIS. So, from what I've heard, confidentiality is really the main concern of producers. And of that, we're going to talk about what the information is that's collected, what does the USDA say about the confidentiality, and how is it possible for someone to obtain the information that's collected. Now we're going to sort of skim through these next couple slides because I'm sure you guys know it better than I do. This information was taken from the USDA website, and it's information that's collected for premises registration. And it includes the premises ID number that's given to the premises, the name, contact, street address, zip, phone number, operation type, date activated, retired, reason retired, all that sort of stuff. And this information goes to the National Premises Information Repository. Each state, if they want to, can also have additional information that they require, but this information is not given, any extra information is not given to this repository. So let's look at the next step of animal identification. When you do that, the information that's collected is all the premises registration information, and then there's also the personal identification number that's later associated with the tags that are given to each individual producer. It's not the ones that are actually put onto the cows or to whatever animal you're talking about, but these are the tag numbers that are given to this premises. And to take it one step further, for the animal tracing, you have all of the premises registration information, all of the animal identification numbering system information, and you also have animal movement records. And these are not kept by the federal government. They are kept by state or private service providers. That's really important to remember, and we'll talk about that a little bit further on. So what does the USDA say about confidentiality? I'm sure if you went to a listening session, you heard all of these statements about what the information will be used for. It says federal law protects information from individuals and confidential business information from being given out to the public, and that they'll only request this information in the case of an animal health event, and that they'll only have limited information available and will have to request it from state or private providers if it becomes necessary because of an animal health event. So, in general, there are 2 different ways that people can obtain information from the federal government. The first is through a FOIA request, and I'm sure Pam knows a lot about that. And the second is through a court subpoena. And that's a little bit different, and we'll talk about it in depth a little bit more in a minute. FOIA is an act that gives the public the right to access federal agency records simply by requesting them. It's used a lot of times in the news media, in whatever fashion, in order to get records that talk about different aspects of the federal government. And these records are agency records that are maintained by agencies within the executive branch of government. USDA obviously is one of those. But for them to be these records, they have to pass this test. They either have to be created or maintained by an agency. And they also have to be under agency control at the time the request is made. And they do not apply to, you cannot request under FOIA, records from private companies, persons with federal contracts, state or local governments. That's not applicable, it doesn't count under FOIA. But it's important to note that each state has their own state-level FOIA law so that you can request state-level agency information under whatever state law applies. Like everything with Congress, they can't just make a law and say this is what the rule is. You have to have lots of exceptions and exemptions, and FOIA is no exception. There's 9 different recognized exemptions to FOIA, but really only 2 of them will possibly apply to the NAIS data. The first one is the trade secrets, commercial or financial information, but the one that's really going to be important is the information specifically exempted by other statutes. So, the question of the day is, must USDA release this information in response to FOIA requests? And there's actually a case that talks about this very thing. According to Judge Sullivan in the District Court of Columbia, no, they don't have to. And what happened was, there was a journalist, I believe she was in Missouri, and she requested this NAIS information. And the USDA refused to give it to her, and she filed suit. And the judge held that it is information specifically exempted by this statute. And we'll talk about it in just a second. And USDA also made another claim, but because the judge said that the specific exemption was enough, the judge didn't even talk about the other claim. But it's important to note that the USDA is arguing both of these things, and both of these are potential reasons not to release the information through FOIA. So the statute is 7 U.S.C. section 8791, and it requires that any officer or employee of the Department of Agriculture shall not disclose information provided by an agricultural producer or owner of ag land concerning the ag operation, farming, or conservation practices, or the land itself. An agricultural operation is defined broadly enough that NAIS information would probably, and in this case did, fall under this exception. As a result, the judge held that this law does apply to the request, and the request was properly denied. In other words, this law says that that USDA cannot release NAIS information. But, like I said, there's always exceptions to the rule. And in this case, Congress did put in several exceptions to the rule. And I know this is a lot of information on this slide, and I believe they're going to be put up later, but I thought it was important that you've heard all of these exceptions. It may be disclosed to a person working with an agency who's providing technical or financial assistance, or somebody who is responding to a disease or pest threat to ag operations. So in that case, this information can be passed out, can be given to these people. They can also disclose payment information. This really wouldn't have anything to do with NAIS, but when you get into farm program payments, they can give that payment information if it's authorized by law. They can also disclose NAIS information if it turns into statistical information. So the 2 gentlemen who spoke this morning with their statistics, it could go to them to give numbers of how many farms this is applicable, to give numbers of how many head of cattle this applies to, but not to give the name, the place, the phone number, the contact information of these farms, or the place where you can find this many cattle. And you cannot give specific data gathering sites either. But an ag operator, a producer, owner, can waive these protections and can say, USDA, give my information to whoever you want. But you can't be blackmailed into doing that. USDA can't come to you and say, well, we're not going to give you any farm program payments unless you decide to waive this protection. And that's written right into the law. So it's up to you. As long as you do not want your information released, USDA cannot do it. However, court subpoena power, I talked about a second ago, that was really the second way that you can obtain information. And what that is during the course of litigation, while a lawsuit's been filed, courts have subpoena power to obtain information for that lawsuit. And just because information is exempted under FOIA doesn't make it immune automatically to the subpoena power. Instead, the judge can subpoena it if the party's need for information exceeds the government's need for confidentiality. And as you can imagine, that can vary from one judge to the next. One judge might feel that the information is very important and release it, and another one might not. But no court cases have addressed this in the NAIS context. So we don't know what the judges would do. And really, the judges don't know what they would do because there are no cases that have actually addressed this and determined whether or not this information is important. The next thing I want to talk about is liability. Now, talking to people, I haven't heard this addressed as much, but I personally think that this is the more important concern. And USDA says, as you can imagine, that NAIS would not expose producers to unwarranted or additional liability. There are three possible ways that liability could be imposed. It could be imposed under a warranty theory, strict liability, or negligence. And we're going to talk about each of them in turn. A warranty is just what everyone knows it is. There are actually 6 or 7 different kinds of warranties. You get different ones when you're buying a house, when you're buying a car, when you're buying just a product off the shelf in the store. And the warranties that would apply in this case would be the warranty of merchantability and the warranty of fitness. So let's distinguish these a little bit. Say you're going to buy a cattle chute, and you pick out which one you want. The warranty of merchantability would apply, saying that that chute is sufficient, is strong enough to hold cattle, that you can run cattle through to work them. Say you're talking to the salesman, and you say, well, I have a couple bison. Will this chute allow me to work them too? Can I run them through? And the salesman says, yes, as a matter of fact, this is the strongest one that's made anywhere. You can run bison through, and it will be just as good. Well, if you try to run bison through and they end up like that picture yesterday coming out the top, that would be a violation of the warranty of fitness because it's a guarantee that the item is fit for its intended use, which would be running bison through, when you, the buyer, rely upon the seller's knowledge of the chute. And the seller knows that you intended to use it for bison. So it's not the ordinary purpose for which it's used, which would be cattle, but its intended purpose, which would be bison. And warranties can be expressly stated or implied. So you can either say, I warranty, I promise that this will work in this fashion, that this chute can be used for bison, that this chute can be used for cattle, or it can be implied. When you buy a chute for cattle, it is implied, even without anyone saying anything, that you can use that chute for cattle. But the kicker here is that only merchants can give warranties. So after your bison runs through the chute, if you decide you want to get a different one, and you put a notice in the newspaper that you're selling it, somebody comes and buys it. You're not warrantying that the chute will do anything because you're not a merchant. You're not in the business of buying and selling these cattle chutes. So, in this context, can a warranty theory lead to liability under NAIS? Like everything in the law, sadly, it's hard to give a straight-up answer. So I'm going to stick with possibly yes. However, as we talked about a minute ago, warranties are only given by merchants. And courts in the past haven't always found that farmers are merchants. This seems to be changing, and there are a couple cases where courts have found that farmers are indeed merchants. And so it's still really up in the air whether this can happen. But some states have realized that it's possible for this to happen, and they've passed statutes that prevent liability under warranty theory. 16 states, actually. And these are the different theories under which you can't obtain a warranty, you can't bring a warranty claim. And I'm not going to talk about these too much. If you want more information on them, you can go on our website, and there's a publication that talks all about them. So the next theory that we're going to talk about is strict liability. And strict liability is imposed when one introduces a defective product that's unreasonably dangerous into the stream of commerce. And it doesn't matter if you're careful, sadly. You can be responsible under strict liability even if you use best management practices in good faith. The elements of strict liability are that the product has to be defective and unreasonably dangerous, and that there must be a causal connection between the defective condition and the plaintiff's injuries. If the product caused the injuries, there's your causal connection. But to do that, you have to prove that the product didn't change substantially after it left your control. And that's where it's become sort of difficult to hold this to livestock, because obviously the product changes from the time it leaves the cow-calf operation to the time it's on the table in the form of a steak. But it could possibly lead to liability. For it to happen, the animals must be defined as unreasonably dangerous products, which the majority of courts say is not true, because that animals cannot be products because they're constantly changing. And it changes substantially once it leaves a producer's hands. But a couple of courts have held that animals can indeed be products. Now, in terms of how relevant this would be, I would say that warranty and strict liability are not going to be the theories that people try to impose liability under. The theory that people are going to try to hold producers responsible for is going to be negligence. And negligence is the failure to exercise reasonable care. I always hate when they follow definitions with definitions, but that's how they do it in this case. And reasonable care is what a reasonably prudent person would do in the same or similar circumstances. It's not very coherent. It doesn't clarify anything. But what judges have done is they define what they consider to be a reasonably prudent person, and if you didn't act in that same manner, then it's considered negligence. There are different elements, different parts of what negligence is. There's 4 of them. There's duty, breach of duty, harm, and causation. You have to have all 4 of these elements or else you're not negligent. So under duty, were you responsible for doing something or not doing something to a certain person or being? Did you fail in your responsibility? Was somebody hurt? And were you the reason that somebody got hurt? And could you have foreseen that somebody would get hurt? Let's put this back into the animal ag context. You have a responsibility as a producer not to feed bone meal from cattle back to cattle. If you fail to do that, if you feed bone meal from cattle back to cattle, you have breached that duty. You have broken that responsibility. If somebody later gets hurt because that cattle has been diagnosed and has BSE, that person has been harmed as a result of your breach of duty. You are the reason that person got hurt. And could you have foreseen that somebody would get hurt? If you are intentionally feeding this bone meal to cattle, made from cattle, then it's reasonably foreseeable that somebody could get hurt as a result. If you're doing something intentionally that you know is wrong, it's very easy to be held responsible for negligence. And can this negligence theory lead to liability? Yes. This is one situation where I'm not going to say yes or no, not going to say possibly. Yes, it can. If a plaintiff can prove that someone down the chain failed to use reasonable care and that failure led to the injury, then that person is responsible, can be held responsible. The good news is negligence can be reduced or eliminated by using best management practices. If you're not doing something you don't know that you know specifically is wrong, it's less likely that you'll be held responsible under negligence theory. And some documentation that supports these best management practices are records, animal health programs, recording your inputs, and not doing things that you know you shouldn't do. In a sentence, don't do that. So the question is, does liability increase if you participate in an animal identification system? And the answer is no, it does not increase directly. Right now, livestock producers are held to the standard that they are responsible for the animals that they produce. And they'll continue to be held to the same standard, meaning you can't feed bone meal from cattle back to cattle. You can't buy growth hormones from Mexico that you know are outlawed in the United States. But the difference is NAIS, or an animal identification system, helps identify livestock producers that might not have been able to be identified before. So it increases their accountability because now you can go back to the farm and say, this is where it started. Before, without an identification system, you weren't able to do that. And this makes it easier to determine who mismanaged the animal and can lead to increased liability exposure. But it's important to remember it does not increase liability straight up. It just allows it to be easier to find out who is the responsible person. So how are these two concepts of liability and confidentiality connected? And I put an example on here. For this example to work, you have to work with me a little bit and imagine that the processor has put something into place to identify from the animal to the package something to continue the NIS system, which ends upon termination. So assume that the plaintiff eats contaminated meat, files suit against the producer, against the processor. The processor wants to reduce its liability by getting other people in to help pay for this. So he wants to bring in the processor who fed the bone meal that he shouldn't have, by bringing in the producer who fed the bone meal that he shouldn't have. So in order to identify this producer, because they don't know who it is, they file a FOIA request, and USDA denies it because of this newly passed statute. Once they deny it, they go a different route, and they ask the court to supply a subpoena that will force USDA to turn over the information. And the court must then decide if the producer's need for information exceeds the government's need for confidentiality, and then make the decision to issue the subpoena or not. So let's assume that the judge decides that the producer's need for the information is more important than the need for confidentiality, and a subpoena is issued and the information is turned over, and the court proceeds with the producer as a party. This is how liability and confidentiality are related, and this is something that has not been addressed in anything that I've read. So I want to talk real quickly about the religious freedom that was brought up yesterday. And there is a case filed in Michigan that has Michigan has a mandatory animal identification program because of tuberculosis. And plaintiffs, who happen to be farmers in the state of Michigan, they filed suit against USDA on two grounds. First, that the national government was forcing them to take part in the identification. And second, that NAIS violated their freedom of religion by forcing them to adopt technology that was against their religious beliefs. These farmers happen to be Amish. And the court said that NAIS is neither a federal law or federal regulation, and instead it's a voluntary program. And because it was a voluntary program, the government wasn't forced, the federal government wasn't forcing anything on the states, and that the states could adopt whatever regulations they felt were necessary. In this case, Michigan adopted the mandatory ID. Therefore, because it wasn't a federal program, mandated federal program, they were dismissing it on that grounds. But argument number two was the religious argument. And the court found that the court basically punted the ball and said because the first argument was dismissed because it's a federal program, you can't really talk about, because it was a state program, you can't really talk about the federal program in the second argument. It's a legal thing. It really didn't tell anyone anything, and it just made the plaintiffs, if they want to refile, they're going to have to file in state court. So the federal court said it didn't have jurisdiction to order state officials to conform to state law, but did not say whether a mandatory federal program would violate these freedom of religion laws. So this is what we've covered today, and there are several issues that I feel are left to be addressed. For the most part, I think concerns about confidentiality have been addressed through the passage of this bill it was part of the Farm Bill last year. Liability is a larger concern, and one that I don't think has been addressed adequately by any agency. But liability is intertwined with confidentiality, and the question is this information able to be subpoenaed by a court order? If that's the case, liability becomes more of an issue. And the last one is, would a required NAIS system violate laws of religious freedom? So on the USDA website, it says that if they have concerns, they'll follow the normal rulemaking process. So if you have concerns, comment. Do just what you did during the listening session and make comments.